His name is Emeka. He is 43 years old. He's a lawyer in Abuja, corporate law, mostly contracts and business registration. He has been practicing for 15 years. He is not a political lawyer. He does not represent politicians. He represents businesses. But Emeka grew up reading Nigerian law. He knows court hierarchy the way a musician knows scales, not because he looks it up, but because it was one of the first things he was taught. Superior courts bind inferior courts. A stay order from the Court of Appeal is not a suggestion, it is a command. A federal high court judge who delivers a substantive ruling after receiving a Court of Appeal stay order is not making a legal mistake, he is making a choice. On June 15, 2026, Justice Peter Lifu of the Federal High Court Abuja made that choice. He ordered the deregistration of the ADC and 4 other parties. He did it despite the Court of Appeal's May 22 directive to stay proceedings. Atiku Abubakar called it judicial rascality. David Mark said the judgment cannot stand. The ADC called it a plot to weaken the opposition. Then, on July 29, 2026, the Court of Appeal did what Emeka knew it would do, because the legal outcome was never really in doubt. A 3-member panel led by Justice Abba Mohammed unanimously declared the Federal High Court's deregistration order null and void. The ADC lives, Atiku's platform survives, the 5 parties are fully restored. Emeka read the ruling at his desk and felt something he did not expect. Not relief, not satisfaction, something closer to worry. Because the question that the ruling answers, was the deregistration legal, is less important than the question it raises. If a federal high court judge can make a choice like that in broad daylight in a politically sensitive case 9 months before a presidential election, what does that tell you about the judicial environment in which Nigeria will conduct that election? What is happening in Emeka's law office is really about something larger than the ADC. It is about whether Nigeria's courts, the institution that every democratic system ultimately depends on, will be an honest referee in 2027. Stay with me. Before we go deeper, if you are just finding Naijanewswatch, welcome. This channel exists to break down what is really happening in Nigerian politics without the noise and without the spin. If that's the kind of analysis you enjoy, hit subscribe and stay with me, because this story is about to get a lot more interesting. Let me give you the full sequence, because the details matter enormously for understanding what this ruling means. May 22, 2026. The Court of Appeal, a 3-judge panel led by Justice Mohammed A. Danjuma, issues a stay order in Appeal CA/ABJ/CV/569/2026. The order specifically directs Justice Peter Lifu of the Federal High Court Abuja to stay further action in suit FHC/ABJ/CS/2637/2025 until the appeal is heard and determined. The appeal is fixed for October 27th. June 15, 2026. Despite that stay order, issued 3.5 weeks earlier, clearly communicated to the court, Justice Lifu delivered his judgment. He ordered INEC to deregister the ADC, the Accord Party, the Action Alliance, the Action People's Party, and the Zenith Labour Party. Atiku called it judicial rascality. ADC Chairman David Mark said the judgment cannot stand. Osun Governor Adeleke reacted with alarm. June 16, 2026, INEC, which had actually opposed the deregistration during the original trial, goes to the Court of Appeal seeking an emergency stay. The appellate court acts within 24 hours, halting the deregistration order. The case is adjourned to June 25th for hearing, then further heard. On approximately July 29, 2026, a 3-member panel led by Justice Abba Mohammed unanimously declared the Federal High Court's deregistration order null and void. The Court of Appeal held that the judgment delivered by Justice Lifu could not be enforced because of the earlier Court of Appeal order staying further proceedings in the matter. This is not a close legal question. The court's reasoning was simple. You had an order to stop. You did not stop. Your judgment cannot stand. The ADC is restored. Atiku's 1.8 million primary votes have a clean platform. The Osun governorship election on August 15, 2026 proceeds with the Accord Party registered. Nigeria's opposition landscape is, for now, stabilized. But the question Emeka is asking in his office is not about the outcome. It is about the choice Justice Lifu made and what that choice tells you about the coming election. Let me explain the legal architecture, because understanding the rules makes clear how extraordinary Justice Lifu's conduct was. Nigeria's court system has a clear hierarchy. Magistrate courts are at the base. The Federal High Court and State High Courts operate at the mid-tier. The Court of Appeal sits above them. The Supreme Court sits at the apex. A higher court order binds a lower court, full stop. When the Court of Appeal issued its May 22 stay order, that order was legally binding on Justice Lifu. It was not advisory. It was not a request. The order specifically directed Justice Lifu to stay further action on the matter until the hearing and determination of the appeal. A court that ignores a superior court's binding order has not made a legal error. It has made a deliberate choice. Section 225A of the 1999 Constitution, the provision used to justify the deregistration petition, does set electoral performance thresholds for political parties. The argument that parties that have never met minimum electoral performance thresholds should be deregistered is not entirely unreasonable as a governance principle. The problem is not the law. The problem is the process: filing a deregistration petition, obtaining a stay order from a superior court, and then proceeding with judgment anyway in a case that directly affects the electoral platforms available to opposition presidential candidates 9 months before a presidential election. David Mark argued that the judgment cannot stand because it does not pass the test of law and due process, and that our democracy must be protected from actions that seek to undermine the constitutional rights of political parties and the choices available to Nigerians. The gray area is the question of judicial accountability. When a Federal High Court judge ignores a Court of Appeal order and is later overturned, what consequence does he face? Under Nigerian judicial culture, almost none. Judges are not sanctioned for erroneous judgments. The system's self-correction mechanism, the appellate process, worked. But it worked at the cost of 6 weeks of opposition uncertainty, media coverage of a deregistered ADC, and the political damage of having the story in the public domain throughout the NDC's primary season. Now, let's map the political consequences, because the Court of Appeal's ruling is not the end of this story. It is the beginning of a new one. Who benefits from the ruling? Most directly, Atiku Abubakar. His 1.8 million primary votes have a clean platform. The ADC is registered, unencumbered, and cleared for the 2027 presidential primary cycle. The ruling came as a boost of confidence for Atiku and Osun State Governor Adeleke, who is seeking re-election on the Accord platform in the August 15th governorship election. Adeleke no longer needs to scramble for a new platform or ask his voters to transfer their allegiance to a substitute party. Who benefits from the narrative the ruling created? The opposition broadly. Opposition leaders and rights groups said the controversy has placed the judiciary under intense scrutiny and heightened concerns about the state of democratic competition ahead of 2027. Atiku called on the judiciary to be watchful, warning that recent events have shifted attention to the judiciary itself. An opposition that can point to documented judicial conduct that a superior court unanimously overturned has a specific, credible accountability argument that no press statement generates on its own. The judiciary's behavior is now part of the 2027 political conversation. Who suffers from the ruling if the opposition's narrative that the deregistration was politically motivated is accepted internationally and domestically? The ADC, Atiku, and civil society organizations are specifically building that narrative, that Section 225A was deployed selectively against opposition parties at a politically sensitive moment by a court that then ignored a superior court's order. Whether that narrative is accurate is contested. That it exists and being amplified is documented. Now, if what I just laid out surprises you, drop a comment below. I want to know your take before we get to the part that changes the whole picture. And here's the part that changes the whole picture. The ADC ruling is a victory for the opposition, but the lawyer quoted at the courthouse after the ruling said something that goes beyond the ADC. This judgment is a victory for democracy in Nigeria. The hierarchy of courts in Nigeria must be respected as they establish an unbroken chain of command, and no court has the luxury to sit in judgment against the correctness or otherwise of orders of superior courts. That statement, "no court has the luxury," is a judicial community telling itself something. It is not just a comment about Justice Lifu's specific conduct. It is an acknowledgement that the judicial community is aware that the 2027 election will produce a wave of legal challenges, electoral petitions, and politically charged rulings, and that the chain of command within the judiciary must hold under that pressure. Because here's the deeper story. Nigeria's 2027 general election will not end in January 2027. It will continue in courts, electoral petition tribunals, appellate courts, ultimately potentially the Supreme Court. The integrity of that post-election legal process determines whether a 2027 result is accepted or disputed. If the judicial system produces a fair post-election legal process, even a close or controversial result can be absorbed. If the judiciary produces rulings like Justice Lifu's, politically timed, procedurally defective, reversed on appeal, the post-election legal process becomes another site of political conflict. The Atiku ADC case is the preview. The 2027 general election's legal aftermath is the main event. Let us come back to Emeka in his Abuja law office. Emeka felt worry, not relief, when he read the Court of Appeal's ruling. Not because the ruling was wrong.
It was right. The outcome was legally correct and was the only defensible outcome given the May 22 stay order. He felt worry because of what the 6-week episode revealed. A federal high court judge made a choice. That choice affected 5 political parties, 1 presidential candidate, 1 sitting governor seeking re-election, and the opposition's entire platform landscape. The choice was wrong. The appellate court corrected it. The system worked. Eventually, imperfectly, after the damage was done. For Emeka and for every Nigerian who depends on the court system to be the honest referee in their daily disputes, property, business, family, the question the ADC case raises is not about the ADC. It is about the referee's reliability. Can the system correct wrong choices fast enough, consistently enough, and credibly enough to function as a genuine safeguard in the most contested election Nigeria has held since 2015? For ordinary Nigerians who have never been near a courtroom, judicial reliability is not abstract. It is the title deed that holds because a court will enforce it, the business contract that can be sued upon, the electoral result that can be challenged. When the judiciary is perceived as politically directed, even if the appellate level corrects the misdirection, the corrosive effect on public trust accumulates. And public trust in institutions is the foundation of everything else a democratic society tries to do. The international dimension of this ruling is specific and well documented. Atiku expressed concern over what he described as conflicting judicial decisions and politically charged rulings, saying the developments had placed the judiciary under intense public scrutiny. His explicit appeal to the international community in his June 15 statement was not diplomatic language. It was a deliberate attempt to make the judicial conduct an international accountability issue before the ADC ruling was delivered. International democracy organizations, the NDI, the Carter Center, the EU pre-election observer missions, all track the pre-election judicial environment as a leading indicator of whether conditions exist for a credible election. A documented case of a federal high court judge ignoring a Court of Appeal stay order in a politically sensitive case, subsequently overturned by the appellate court, will appear in every international election environment assessment published before January 2027. The Osun governorship election on August 15, 2026 is the most immediate electoral consequence of the ruling. Governor Adeleke contests on the Accord platform, one of the 5 parties that was deregistered and then restored. Whether the election proceeds cleanly or whether any post-election petition attempts to relitigate the party's registration status against Adeleke's candidacy will be the first real-time test of how the opposition's restored legal standing performs under electoral pressure. For the diaspora, the ADC court saga encapsulates the concern that has shaped Nigerian diaspora political sentiment for a generation, that Nigeria's institutions, even when they ultimately produce correct outcomes, operate in ways that create uncertainty, damage, and fear that should never have been necessary. The Nigerian diaspora Nigerian who is assessing whether to return, invest, or engage politically is watching this episode as evidence of an institutional environment that is not yet safe for the kind of long-term commitments they would need to make. Let me give the strongest argument for why the ADC episode does not represent the kind of systemic judicial crisis the opposition is claiming, before explaining where that argument falls short. The argument is this: the appellate system worked exactly as it was designed to work. A lower court made an error. The error was appealed. The Court of Appeal corrected it promptly, within 6 weeks, before any election was affected, before any candidate was removed from a ballot, before any voter was disenfranchised. The system self-corrected. This is not evidence of a broken judicial system. It is evidence of a functioning appellate process. No democratic system prevents all judicial errors at the trial court level. The question is whether the appellate system corrects them, and in this case, it did. Moreover, the Section 225A deregistration provision is a real constitutional requirement. Parties that have never met minimum electoral performance thresholds consume regulatory resources, confuse voters, and create political vehicles that have no genuine electoral accountability. The principle behind the deregistration petition is not unreasonable, even if its timing and procedural execution were flawed. That argument is substantial. The appellate system did work. The outcome was correct. The constitutional principle underlying the petition is legitimate. Where it falls short is in the specific conduct. It is not enough that the system self-corrects. The self-correction must be fast enough to prevent real damage. It took 6 weeks, one emergency appellate intervention, and a unanimous Court of Appeal panel to undo what one trial court judge did in one afternoon. Those 6 weeks coincided with the NDC's primary season, the approach of INEC's candidate registration discussions, and the political moment when the opposition needed maximum institutional clarity, not maximum institutional uncertainty. And the deeper question, which neither the government nor the judiciary has publicly addressed, is why Justice Lifu proceeded with his judgment despite receiving the Court of Appeal stay order. The ruling was overturned. His conduct has not been examined. Here is what to watch following the Court of Appeal's ruling. Watch the Osun governorship election on August 15, 2026. Governor Adeleke contests on the Accord platform, one of the 5 parties that was deregistered and then restored. Whether the election proceeds cleanly or whether any post-election petition attempts to relitigate the party's registration status against Adeleke's candidacy will be the first real-time test of how the opposition's restored legal standing performs under electoral pressure. Watch whether any further deregistration petitions are filed against ADC or other opposition parties before INEC's candidate registration deadline. A single deregistration petition can be dismissed as opportunistic legal action. A pattern of such petitions, targeting different opposition platforms at different stages of the election cycle, would confirm the systemic concern that Atiku and the opposition are raising. Watch the court specifically for any new Section 225A suits filed between now and October 2026. Watch whether any civil society or legislative accountability process examines Justice Lifu's conduct. The National Judicial Council has the authority to examine judicial conduct. Whether any complaint is filed about Justice Lifu's decision to proceed despite the Court of Appeal stay, and whether the NJC takes up the matter, will tell you whether the judicial community is willing to hold its own members accountable for conduct that is Superior Court unanimously overturned. Watch the Supreme Court's pre-election pronouncements. The Supreme Court periodically issues statements or pre-election circulars about election conduct and judicial standards. Whether the Apex Court makes any pre-2027 pronouncement about judicial conduct in election-related cases, affirming the hierarchy of courts and the binding nature of appellate orders, would be a significant signal of the judiciary's institutional self-awareness ahead of what will be its most contested season in a generation. Worst-case scenario. Further deregistration petitions target other opposition parties. Lower courts continue to produce politically timed rulings that the appellate system must repeatedly correct. The pre-election judicial environment becomes chaotic, and the 2027 election is followed by a wave of election petitions in a court system whose integrity is already being questioned. Best-case scenario. The ADC ruling produces a judicial culture signal. Lower court judges understand that politically timed rulings ignoring appellate orders will be reversed and potentially scrutinized, and the remainder of the pre-election period produces a judicial environment that is perceived as credible enough to conduct a fair 2027 electoral legal process. In that scenario, The system's self-correction in the ADC case becomes the precedent that protects the integrity of the 2027 process rather than undermining it. At the beginning of this video, Emeka read the Court of Appeal ruling and felt worry, not relief. The outcome was right. The process had been wrong. Here is the answer to the question he was asking. The Court of Appeal's unanimous ruling, declaring Justice Lifu's deregistration order null and void, is the judicial system asserting what Emeka learned in his first year of legal practice. The hierarchy of courts must be respected. Superior court orders bind inferior courts. No court has the luxury of choosing which orders to follow. That assertion is important. It is not sufficient. Important because it was made publicly, unanimously, and in terms that left no ambiguity. The ruling is a legal community speaking clearly about what proper judicial conduct requires. Not sufficient because the episode that produced the ruling, a trial court judge ignoring an appellate order in a politically sensitive case 9 months before a presidential election, should not have needed to be corrected. Prevention is better than cure. And the cure, while applied, came 6 weeks later after real political and institutional damage was done. For Emeka and for every Nigerian who depends on the court system to be the honest referee in their daily disputes, property, business, family, the question the ADC case raises is not about the ADC. It is about the referee's reliability. Can the system correct wrong choices fast enough, consistently enough, and credibly enough to function as a genuine safeguard in the most contested election Nigeria has held since 2015? What do you think? Has Nigeria's judiciary done enough to prove its independence before 2027, or is the ADC ruling too little too late? Drop your analysis in the comments. If this breakdown gave you clarity on what is really going on, do me a favor and share it with one person who needs to understand this. Like the video, subscribe to Nigerian Watch, and I will see you in the next one. Stay sharp.